potential for us now to understand about IP, as well as, of course, earlier it was a kind of luxury. Some people only can focus on it, but now it has become a kind of essential part of our life, and how you can monetize that. That is really important to understand for us. Let's start with this kind of idea. So. So I'll just give a quick overview about our firm, K&S Partners.
So one more. When my charge is this.
Yeah. So our firm was founded in 1994. It's a IP boutique firm. So we focus on filing patents, trademarks, copyrights, geographical indications, and trade secrets for our clients. So usually the law firms in India are family based. So contrary to that, our law firm is based on meritocracy of the employees or the people. Based on that, we promote our colleagues as a partners. So, which is usually not the case in family-based law firms. So, we have offices across India in 7 locations: Gurgaon, Bangalore, Hyderabad, Mumbai, Chennai, Delhi, and Pune. So, Pune is the recent one. So our vision is to become the finest law firm in India. It is not that we need to reach the top companies representing company, not that kind of sort. We wanted to be the finest firm with the quality of work that we deliver to our clients. So as I mentioned earlier, we usually take care of patents, trademarks, copyrights, trade secrets, as well as geographical indications along with the plant varieties. In this course of work, we primarily do advisory work, prosecution work, as well as protection of their IPs and the transactional work as well as which includes licensing, assignments, arrangements of agreements, etc. Okay. Now, usually when we say property, generally it is a kind of measurable thing. If you see, like money or assets, like for example, real estate, if you see, you can measure, you have so much land and you can protect it in the form of various measures, right? And of course, you can quantify it. But what we are talking is intellectual property. Can we really measure this? And when we are telling about, measurement, and then really can we protect it, and is that protection is actually required? Let's see with this one example which I would like to so this was in year 1988. In front of a crowd of 40,000 people, a man did a jaw-dropping performance where he leaned at 45 degrees angle. He did not fall down, he did not wobble, but after giving that lean position of 45 degrees for a certain period of time, he came back to the position, and it was a mesmerizing performance. And for 20 years, nobody could do that performance. Now, can anybody guess who could have done this? Yes, correct. So, yeah, I mean, it's very obvious because it was a kind of his patented invention that made him to have that kind of protection for 20 years. So, what is the secret behind that lean? Does anybody know actually what he has done? Let's see. So, MJ leaned forward at 45 degrees but did not fall. Why? Because he has developed an invention. This is a basically hardware innovation where a shoe-based anchoring mechanism designed to allow a performer to lean beyond their center of gravity without falling. So that's the science behind it. And it's not just that kind of any technique that he used to do this, but it's a kind of science. There is a behind of that leaning position. You can see the kind of pictorial representation that was depicted in the patent also. And this is the kind of shoe that he has designed to do this kind of an act. And this was the patent 5255452, and the title of this patent was Method and Means for Creating Anti-Gravity Illusion. So, since he has a protection, so as I said earlier, he has given this performance in 1988, but of course, this was published after 5 years. So then people got to know, okay, there is a mechanism or science behind it which made him to give this performance. Okay, so until the completion of the patent term, nobody could do this, because if anybody does that kind of an act without his permission, he will be liable to a punishment because of the patent protection that he has for this kind of shoe, okay, and the method that he has developed to do this kind of an act. Okay, so that gives a monopoly for him for a period of 20 years, where he can encash or monetize whatever the innovation that he has developed. Having said that, of course, now you can really understand the importance of protecting your intellectual property, because you can monetize it, and of course later after a period of 20 years that goes off patent, but still you could have got the benefit of being a monopoly for the period of 20 years. Having said that, let's get into a quick refresher about the intellectual property. So it's an intangible asset. Because of the human intellectuality and the skillfulness, any person can come up with a kind of unique or novel solution to the problem that is there in the society. And because of that, whatever the kind of solution that he has produced for the problem, he will be rewarded with a kind of grant, so-called patent, and 20 years he will be having a monopoly over it. And of course, when we are talking about a problem solution approach, that would be primarily focused with the patents. Besides that, there are different forms of intellectual property. We will see quickly about all those aspects which fall under the umbrella of intellectual property. So it is usually considered as a business asset. And what are the kind of benefits that any organization or innovator will have having the proper protected IP is: one, company can have organic growth because you have a monopoly, and because of which you can monetize the whatever the property, intellectual property that you have developed, and that helps for sustainability of an organization. And also it would act as a asset created product. Moreover, it also gives a recognition in the society for developing such kind of products. I'll give some of the examples also, and how we helped some of the organizations when they have come up with innovative products or patents, and how that helped them to get some kind of unique place for those companies. So also it promotes the attention in the society for such an organization if they have done something unique, out of box solution if they are providing for any kind of problem that exists in the society. And also, of course, the moment you get that kind of recognition and attention, that helps you to get the fund, which is a commercial success again. So apart from the patents, you can have several other assets with your intellectual creativity. That includes copyrights, trademarks, etc. So let's deep dive into the kinds of IPRs. So under the umbrella of intellectual property rights, we have various forms of IP. If you are providing a problem to a solution, if you are providing a solution to the problem, then it is a patent. Otherwise, if you have come up with a kind of aesthetic appeal to any kind of device or a product, then it can be subjected and filed under the design patent. So in that way, we have these forms of IPRs: patents, designs, integrated circuit layout designs, geographical indications, you know, like Mysore sandal soap, that falls under the category of geographical indications. And Tirupati Laddu, Kundapalli Bommalu, Kolhapuri Chappal, these are all some of the categories that fall under the geographical indications. And plant varieties, copyrights, trademarks, which are also called as brands. So again, trade secret, if any company does not want to disclose their product details in public, and they can keep it as a trade secret. So primarily that includes Coke as a typical example. If you see Coca-Cola, till now nobody knows what is the exact formula of the ingredients that are present in a Coke drink, but still, you know, that product is a revolutionary. So usually this trade secret will be for the innovations where reverse engineering will be very challenging. So in those scenarios only trade secret would be adopted by the companies. But of course, if reverse engineering is very easy, then it is always an ideal way to go for a patent protection. Okay. So now we have different forms of IPRs we saw. Now we need to understand what has to be protected under what form. Okay. So if, let's say, if you are taking a robo an example, if you are looking at the functionality of the robo, then patent would be a right way of protecting it. And let's say if you are talking about the shape of robo, then designs. Designs plays a crucial role because the aesthetic appeal comes up with the designs, so that can be protected through design patents. And if you are developing a source code for the working of that robo, then that can be protected through copyright. And of course, brand name or any trademark can be protected. Brand name of the robo can be protected through trademark. And we'll take another example for your further understanding in this regard. How an IP can be given for a eye drops bottle. If you see, design of the bottle can be protected now using design protection, and trademark will be for the brand name. Whatever the eye composition, eye drops composition that is there, that can be protected through patent. So of course, I think now you guys would have got some idea how you need to choose your IP based on the kind of intellectual property or intellectual information that you have developed. So now, with respect to the term of protection, all these IPs are guided by different or explicit laws. For example, in case of patents, we have Patent Act. In case of trademark, similarly we have Trademark Act. So likewise, copyright, of course, Copyright Act. So Indian Patent Office has developed several acts, enacted basically. So trademark, if any company has developed a brand name that they can protect for 10 years, and of course, further renewals can get it. The renewal, having the trademark protection, without any kind of further limitation. So it is kind of, you can say, perpetual. In case of copyrights, life of the creator, if it is a book, then it's a life of an author plus again 60 years. So that kind of protection can be seen. In case of plant variety protection, it's crop yield for 15 years and plants for 18 years. So that's the kind of protection. So in case of geographical indications, 10 years, again renewal is allowed here. In case of trade secrets, it's like eternity because nobody knows the formula because they can't do reverse engineering. But of course, if they can do reverse engineering, there is no point of having the trade secret. So basically here an organization needs to take a call whether I need to go for a trade secret protection or a patent protection based on the complexity of the composition or the product that they have developed. So another one is integrated circuits. Again, the protection term is here for 10 years, patents 20 years, designs 10 years, followed by renewal. Again, they'll be getting 5 years protection. So these are the brief timelines of protection or the term that one can get after protecting their intellectual property with these forms. So yeah, I think I already mentioned that Patent Act is there, Copyright Act is there, Trademark Act is there, for designs, Design Act is there. Trade secrets, of course, as of now in India there is no as such an act, but yeah, it is in under discussions. Indian government is working on this to get appropriate law or guidelines to give information to the innovators or companies to handle trade secret related aspects. So if you have developed a new invention, then that can be filed under the Patent Act as a patent application, and then it will be subjected for an examination followed by the grant of it. And in case of any creative work or artistic work, that exists automatically, basically. But yeah, having a copyright protection through proper filing of application will give a upper edge. So in case of trademarks, distinctive identification of products or services, like products means you can see all the Tata products, of course, starting from the grocery or Tata product, again, Titan is a watch from the Tata brand. And in case of service-based companies, if you see Ola, Uber, Zomato, these are all the Swiggy, these are all service-based organizations. So they usually protect their brand names using the Trademark Act provisions. And whatever the external appearance that is associated with any kind of product, basically shape of a bottle. If you see Coke bottle that have, every 2-3 years they come up with a unique shape that will be very appealing because it has to attract the attention of the customers, because that only gives a business to them besides the quality of the product, right? So that is also one of the unique feature that can be protected through Design Act by appropriate registrations associated with it. I talked about trade secrets already. Okay, now we need to understand the difference between invention and discovery. Invention means with a human intervention, somebody develops it. Whereas the discovery means it is already there, probably somebody would have not noticed how it acts, but you are the first time identifying for it, you don't get any benefit out of it because it is naturally happening in the law, or it is something which is happening without human intervention, without applying your skill, but you just identified it. Because of that, it is of course called as a discovery, and those are non-patentable. So yeah, just to give a quick information about it, the differences between the invention and discovery. Something has been developed new, then it is called, of course, that can be well to go for filing a patent application. If it is already existing in nature, that is called a discovery, and it is not, of course, patentable. And here human intervention is required. It is like unearthing the scientific principles, so that does not give anything. For example, E equals to mc square. Though Einstein has come up with that equation, but it was there by science. In the sense, nature has that equation. It is just he come up with that kind of equation, so it is not protectable. Okay. Edison invented bulb. That's patentable. Edison discovered Edison effect. It was already there in the nature, so he just identified or discovered it. So that's not again patentable. Yeah, that's a brief information about it. Now we will deep dive into actual core topics like patent, copyrights, etc. So what is patent? It's a kind of protection given for any kind of problem for which a solution has been identified by an innovator or an inventor to address that kind of problem. So now when it comes to the Indian Patent Act point of view, only product and process are patentable. When we say, of course, use is not patentable, but some countries permit it. Every country has, their own law. So accordingly, Indian Patent Act permits only new product as well as the process. So products usually include, like if you have developed a drug, or if you have developed any kind of machine, or if you have developed. One moment, please. Can you go back? Yeah. So if there is a system, apparatus, component, composition, drug, food product, any chemical ingredient that you have developed, those are they fall under the category of product. On the other hand, for preparing these product, if you developed a methodology, that can be filed under a process patent. Okay, so basically it has to be again a new product. If there is a product already, you know the product. If somebody is taking 10 steps or 10 ways consecutive 10 steps they require to produce the product. And if you are able to produce the product within 5 steps, which means you are coming up with a new process, that is again allowed for patent filing. So what kind of rights the patent owner, nothing but patentee, will get after getting the grant of patent? Let's see those. So patent is usually called as a negative right. Owner has exclusive right to prevent others from undertaking certain activities. So that's where it is usually considered as a negative right, because it stops others doing that work, right? So without the patentee's permission, nobody can do some of the activities like making, using, offering for sale, selling, and importing. If any person does this kind of activity without the permission of the patent owner or patentee, then according to the Patent Act, the person who has done these kind of activities would be punished. Of course, there are timelines and the penalty amount, all those things associated with it. But just to give a quick idea, like such kind of an act is considered as an illegal activity, and that is subjected to a kind of imprisonment. So there are serious consequences for it. So one has to take care. So don't copy any patented product without the permission of the owner. That's where they can monetize it. So with respect to the patented product, using, offering for sale, selling, importing products made by using other processes, of course, all these would be construed as a kind of illegal activities and they will be punished. So now, when it comes to the patent protection, whether it is territorial or non-territorial, it is territorial in nature. What does that mean? So, if you are filing a patent application in India, you will be having protection only in India. And a person sitting in US, he can copy your invention unless you get a patent protection even in US as well. So, it's very important to understand that if you have a market value for your product across the globe, or see, actually patenting on the process involves a huge amount of money, so funding would be an issue sometimes. So you have to see the various potential market for you. If you have funding issues, accordingly you need to see which are all the countries where I need to file my patent application. Based on that, you take informed decision. So like, let's say US, Europe, and India are the major markets for your product, then you protect your patent in those countries only. But of course, we have under PCT system, which is international, application, PCT application, which means under that 158 countries are there currently. Of course, that number will be keep increasing. There are non-PCT countries also. Of course, there are like many more. So, but the point here is PCT countries have well-designed patent protection system that helps you to get proper kind of monopoly. Okay, that helps you to have monetization of your patent. So identify the commercial markets where you can monetize your invention and accordingly take a call where you need to file your patent application and get the grant of it and to enjoy the monopoly. So don't expect that if I'm filing a patent application in India, I'll get protection across the globe. So yeah, that's the kind of takeaway from that slide. So this is partly I have covered broad category of patent claims that covers product as well as process, primarily with respect to the Indian Patent Act. So now, like, what are the kind of requirements if you have to file a patent application in India? And of course, anything can be filed, but only thing what can be granted by the patent office is if your invention meets these criteria, which are nothing but novelty, non-obviousness, which is also termed as inventive step according to the Patent Act, and industrial application. And of course, industrial application again subjected to the national laws of each and every country. So if you see this one, problem, solution, invention. So this is the route generally that helps for developing the innovation. If you see a problem around you, you try to address it by providing a unique solution with your unique approach, then that helps you to get the grant of patent. We'll see some examples, of course. So now what is meant by novelty? So it is like apple to apple comparison. Like if there is any product, exact replica of it is there or not. So that tells novelty. So just by bookish things, if you see a proposed invention is considered as novel if it has not been known in the very form anywhere in the world, if it has at least one new element or a combination that has never before been publicly disclosed in art, or if it has not been disclosed in a single document in the same form, an invention is either novel or not novel, deserves the art. So which means, let's say if you have identified a pencil with unique properties, same kind of properties, if somebody has already published or documented or started selling in the market, then you don't have the novelty for your product. Otherwise, yes, you have the novelty. So that is the simple way to look at about the novelty. The next element is, of course, I have captured a quick example here. So the prior art says a pesticidal composition, you know, right? Like if there is an agricultural farming land, usually farmers will apply these pesticidal compositions to control the pests. Okay, if that contains three components, let's say, let's assume, rather than going to the technical names, they are like A, B, and C. If somebody comes up with an invention A, B, C along with the D, that becomes a new ingredient that makes the composition novel. So of course there will be a challenge again, something called inventive step. We'll talk about it little later. So we will see now the second important aspect, which is nothing but inventive step. So substantial and significant difference from the state of art. So it should not be a kind of easy solution for a person skilled in the art to address that problem, which means it has to be unique, having some kind of economic significance. That kind of, it could be either or, like it should be innovative approach or it should have economic significance. So if both are combined, of course, that would be ideal way to address the inventive step issues or challenges. And if you see enhanced technical effect, whenever we say with respect to the inventive step, I got to know that some of you guys are computer application students. Having said that, I've captured these aspects. Like if your invention is particularly with respect to computer applications, what kind of technical that effect with your invention that you need to show is higher speed of your system. If you have developed any kind of tool or an app, then that needs to have higher speed. Like buffering would be one of the challenge when you are using any applications. So if you are able to address that with your innovations, then that would be a way to demonstrate the technical effect. Another way is reduced hard disk and memory access time. Okay, like if let's say an image is taking good amount of your storage space, and because the picture size or the video quality is really good, whatever the GBs, etc. But if you are addressing that problem and you are able to store it in a compact size, let's say if 100 MB video is there, you are able to concise it into 10 MB without altering its quality of the video, then that would be again a technical improvement that you are showing for your invention. And improved reception, transmission of a radio, electromagnetic communication signals. Of course, this is little related to networking systems. And real-time monitoring and control of devices leading to technical solutions to a technical problem. This is one of the challenge usually you can see in case of patients in an hospital. Of course, some patients, they don't want to stay in the hospital for a long period, and they of course wanted to go home and stay, but their blood level, blood glucose levels, or urinary output levels, all are monitored through a watch or a kind of system that is integrated with the human body of that patient. So those kind of solutions are real-time monitoring devices. And security enhancement in computer networks and systems, of course, to protect from the cyber threat. Efficient image processing. Okay, another one is efficient image processing, where if you are given with any kind of particular image, and how quickly you can process it, and how you are able to get the required solution out of it, and better control of the robotic arm. This is of course still existing challenge. You are able to give some kind of instructions to the robot, but sometimes it may be successful, sometimes you might be facing challenges. But if you are able to design any kind of robo system that actually and accurately follows your instructions without any kind of failures. That would be again a kind of technical effect that you can show for your invention. So those are few examples. So there are certain tests that can help you to understand how inventive step can be assessed. So those are like surprising results with respect to the cost, time, yield, and unique approach for solving common problem. And if there is any hindsight, surprise, or simplicity of technology, that is one thing. Disruptive solution if you are providing for any existing problem, that is again address it through inventive step aspect if there is any objection. So similar example what we have taken earlier with respect to the pesticidal composition, that again I have taken for addressing the inventive step objection. So let's say if pesticidal composition having ABC components have best mortality rate 50 to 60% because of the addition of fourth ingredient D. If you are able to have the pest mortality rate 80 to 90%, then that is a kind of improved technical effect that can be seen with the pesticidal compositions. So that's the way how one can produce inventive product when they are working on any kind of inventions. Okay, the third part or third element that requires to be fulfilled for any invention to be protectable is abstract industrial application. So it has the invention should have some kind of industrial utility. Without having such kind of industrial use, such kind of inventions, these are all non-patentable.